This presentation has been prepared as part of the Romani Influence curriculum, elaborated for the purposes of PAL Sound project. Module 2. The Copyright Specific Legislations, developed by PAL Network. Aims of the module: introduction of basic legal terms regarding intellectual property, in-depth explanation of copyright terms and procedures, in-depth explanation of categories of rights and protection for avoidance of infringement, testing of the knowledge received through examination of case studies. Topics: intellectual property. What is copyright? Who is the author? Rights, legal protection, specific legislations. Learning outcomes: knowledge on the basics of intellectual property, in-depth knowledge on legal terms that affect musicians, such as copyright, category of rights, and others. Practical skills development through the examination of case studies for legal procedures. And let's begin with the theory. Intellectual property is protected by law, and it is divided into two subsets: copyright and industrial property. Accordingly, there are several types of intellectual property, like trademarks, industrial designs, and others, while copyright refers specifically to the protection of creators' rights. The above presented are the main industrial property types. Patents. When inventions are made, they are granted an exclusive right. In this case, this exclusive right is referred to as patent. It gives the owners the authority to control how the invention is applied by third parties. Trademarks. A trademark is a marking used to separate an enterprise's goods and services from those of other companies. Industrial designs. These refer to an item's decorative or aesthetically pleasing features. An industrial design may include two-dimensional elements like patterns, lines, and colors, as well as three-dimensional elements like the shape or surface of an object. Besides the above-mentioned types of intellectual property, there are another two to be mentioned. These are the geographical indications and trade secrets. The first are labels applied to products with a particular place of origin and qualities, a name, or traits that may be directly linked to that location of origin. Trade secrets. Trade secrets are protected by intellectual property rights and can be both sold or licensed. Unfair practices that violate the protection of trade secrets include unauthorized acquisition, use, or revelation of such secret information by others in a way that is against honest commercial practices. Copyright is a legal term that describes creators' rights over their artworks, whether they be literary or of any other artistic form. The term can also be referenced as author's rights. The works that are covered by copyright concern a range of artistic works such as books, musical pieces, paintings, films, etc. Broadly, the works that are protected and covered by copyright are the following: literature, meaning all kinds including novels, poetry, newspaper articles; films, music, choreographies, paintings, sculptures; architectural works, advertisements. However, there are some specific concerning what can be copyrighted or not. Specifically, ideas are unprotected. That is because copyright works need to be materialized or expressed in any way. Therefore, procedures, ideas, methodologies, concepts, or daily news that are not in the form of journalism but simply media information are not protected. On the contrary, oral works or works materialized and expressed in any official way are protected. Registration of copyright. In many countries, there are specific copyright systems and regulations for voluntary registration of artworks. These systems seek to provide solution over doubts on who holds ownership over a creation, hence facilitate financial transactions, transfer of rights, etc. However, in most countries, due to the Berne Convention, copyright protection does not require specific registration, but is automatically gained with one's creation of their artwork. Authorship is another important matter concerning the creation of any kind of artworks and their protection by any form of regulation. First and foremost, it needs to be highlighted that an artwork's author can be only a natural person, not legal, because the authorship and protection derive from the individual's intellectual creation. However, there are many situations in which the author is not a single person, but there are more authors that create an artwork. In this case, there are two categories distinguished: authors of compound works and co-authors. Authors of compound works. Compound work is created by consolidating authors' separate created works for joint use. Precisely, when referring to compound work, we mean that authors created their own separate artworks and then connected them, like in music songs, for consolidated use. The important note here is that each author holds rights over their own individually created part of the compound work. Hence, their part can be used by them separately in any way they desire to use it, even though it is part of the compound work. Moreover, the compound work is always mutually agreed with contracts that regulate the mutual relationship between the authors. If that is not the case, then all authors are entitled to equal share over the compound work. An example would be a music song, which might be created as the connection of the lyrical part with the musical composition by two or even more different people who then consolidated their creation to produce a song. Co-authors. Co-authors create a work jointly from the beginning. In this case, we refer to the creation of one work that's been developed jointly by the co-authors instead of the creation of separate parts that later constitute a compound work. Accordingly, co-authors acquire joint copyright over the work created. Any contributions regarding the commonly created work cannot be used in an independent matter because we are not talking about a compound work with separately created parts. Moreover, co-authors' mutual and legal relationship is again officialized by the signing of a respective contract. If not, as it applies to compound works, the co-authors are entitled with equal share over the work. An example would be the creation of a movie with screenwriters, directors, photographers, etc., all cooperating to create one single work of art. Copyright in music. Music is unique in that every track has two copyrights. One of these is a copyright in the song, that is, the musical composition, which consists of the lyrics and underlying music, be it instrumental. The other is a copyright in the sound recording or master recording itself. For example, All Along the Watchtower was originally written and composed by Bob Dylan. It has been subsequently performed and covered by several artists, including Jimi Hendrix. In this situation, the copyright in the underlying musical composition, the lyrics and musical arrangement, is owned by Bob Dylan or his publishing company, while the copyright in a particular sound recording, such as the Jimi Hendrix version of this track, is owned by Jimi Hendrix or his record label. As stated before, copyright also stands for author's rights, since it is used to describe the rights that creators hold over their works. There are two main types of rights. Economic rights. These rights are derived from the term enable the creators to gain money when others use their work. For example, a writer gains money when someone buys their book. The author, as defined by regulations, have the economic right to have specific control over the use of their artworks. Besides, the author is enabled to prohibit the following: reproduction, public performance, recordings, broadcastings, translations, or even adaptations. Moral rights. These kind of rights protect other aspects of the author's interests, not economic ones. For example, moral rights constitute the right to claim authorship over an artwork in cases of infringement, or to oppose changes to a work. Important note: the moral rights belong only to the natural person who's created the work and constitute the emotional value that follows the work. On the other hand, economic rights belong, of course, to the specific author of the work, but they might also belong to other natural or legal persons. For example, to the publishing company where a writer might have published their book. Besides, economic rights constitute the economic value. Exclusive rights. These rights are held by the author of an artwork and give them the authority to prohibit the usage of the copyrighted work. Remuneration rights. These rights concern only the remuneration of the artwork, which is benefiting the creator, and there is no possibility of authorizing or prohibiting the usage of the artwork. These categories are both regulated by the law, even though there are differences between the countries. An example concerns the exclusive and remuneration rights of writers. A writer's exclusive right concerns the incorporation of paintings and illustrations in a book, which are protected with exclusive rights. However, a writer and/or painter, illustrator hold remuneration rights for the renting or lending of the respective book. Performers, natural persons. They may be actors, singers, musicians who have rights related to their performances. The rights are both moral and economic. Producers, natural or legal persons. They are mainly responsible for the first fixation of the work, being audiovisual or phonogram, and hold economic rights only, either of their own or transferred from the authors. Broadcasting organizations, legal persons. They hold responsibility of editorial aspect of the work, develop and distribute broadcasting programs with economic rights only. Publishers, they can be from press publication, with the new right nowadays related to digital use of publications, and written editions where they hold their own rights only regarding the first publication of previously unpublished books, and these are economic. Usage of others' rights. What is fair use? What is limitation of rights? What is public domain? fair use, limitation of rights, and public domain. Limitation of rights. There are certain conditions that must be fulfilled regarding the usage of someone's rights and the limitations that are ensured under copyright laws. The conditions are the following. The case in which someone is using someone else's rights must be described by law. The case must not cause conflict with regular use of the work. The case must not cause harm to the interests of the person that holds the rights over the artwork or work. All these three conditions should be fulfilled to use others' rights, and the usage should usually concern non-commercial purposes. Public domain. Artworks or works that so-called enter the public domain have their rights being expired, with differences throughout the world regarding the duration of expiration. In most countries, the rights are expired after 70 years from the author's death. Once an artwork has entered the public domain, it can be freely used by ensuring that it is compliant with the basic moral rights. Creative Commons also concern the works that have entered the public domain. However, works that are published with this license can be used in accordance with this license. For example, specific reference rules are ensured. Legal protection. In this last section, it is provided basic information on the legal protection of someone's rights over their artworks. The main aspects concerning this part consist of the already mentioned duration of an author's rights, as well as the basic procedures envisaged for the protection. The main different procedures for the legal protection of rights are civil procedures conducted between civilians, criminal procedures regarding crimes of infringements, administrative procedures, insurance of authors' rights in the United States of America and in Europe. Different contexts are applied between Europe and the United States of America. In Europe, there is no need for specific registration procedures, since the protection of the rights starts with the creation itself, as long as the author is able to prove that they created the work and when they created it. In the United States, though, registration is needed. Accordingly, as mentioned before, there are differences in terms of rights duration. For authors, until 70 years after the author's death. For performers, after 50 years of the performance, if published on phonogram, again 70 years. For producers, after 70 years of recorded publications, or after 50 years after video publication fixation. For broadcasting organization, until 50 years after the first transmission. For publishers, until 2 years after a press publication, also used digitally, and until 25 years after the first publication of written one. And now it is time for our practice session. Let's review some commonly asked questions from this module and solve any queries. What is intellectual property and how is it divided? What are the types of intellectual property under industrial property? What falls under copyright protection? Is copyright registration necessary and how does it work globally? Who can be an author and how are rights handled in collaborative works? What are economic and moral rights in copyright? Examination of case studies. This interactive exercise aims at putting the received theoretical knowledge into practice by reviewing specific case studies related to copyright, infringement, rights, etc., and reviewing their context. The participants will be requested to comment on these case studies and test the knowledge received. Thank you for your attention.